Okay, so today we're going to be talking about estate planning for blended families. My name is Krista Hermance. I'm an estate planning attorney. Our firm is Hermance Law, where we focus on planning for families with minor children. However, we do planning for all ages. And so today we're going to be talking about blended families and planning considerations. These are our amazing attorneys that we have working in our firm. So if you are looking at estate planning and putting your plan together, these are probably one of the attorneys that you would be working with and being able to do that. Our team here is a very family-oriented firm. It's really about making sure that we have that work-life balance, that anybody in our team is able to make the award celebration on a Friday morning at 9 a.m. because that's what their school is doing that week. So it's really about making sure that our firm employees have that flexibility. Just to give you a little bit of information about us. So we have offices in Ventura, Westlake Village, Santa Clarita, Calabasas, Irvine, Pasadena, and virtually throughout the state of California. I do a lot on Instagram. And so generally I have a lot of people that will join these webinars that maybe are not located in California. So I just want to make sure it's very clear you are absolutely able to listen to all of this. However, state law is different in every state. We are licensed in the state of California. And so it's all great information if you're not in California, but it's always best to work with an attorney where you are located. Okay. So as we get into this, and again, I'm going to try and keep it to 30 minutes for you. I do want to be mindful of your time. I want to go through 4 different scenarios that I have seen firsthand. These are clients that I've had, or a famous one that we should all know, to kind of give you an idea and to kind of get you thinking on when it comes to blended families, why is estate planning so important? So first one is relating to an investment account with a prior divorce. And so I had this come up in a case where the sister had passed away and her sister was the executor. We had to go through probate. She didn't have a trust set up. And so we were going through probate, and as she was going through and getting all of the assets, she found this investment account. So she contacted the investment company and identified who she was, provided the death certificate so that she could get the investment account put into the probate estate to be distributed to the beneficiaries. So in her communications, she found out that the money had already been distributed. And the reason for this was that sister was married about 20 years ago and got divorced. And sister had never updated her investment account information to take her ex-husband off. And so when sister passed away, her ex-husband got the death certificate, sent it to the company, and took the money from the investment account because he was listed as a beneficiary. So I tell you this as a caution, right? If you are in a blended family situation, and so you were married previously, potentially, check and see who your beneficiaries are. Just because you were divorced doesn't mean that automatically cuts off all ties to any assets that you had with your prior spouse. And so it's always a good idea to just go through and start looking at those accounts and see and pulling who's the beneficiary on all of these accounts. It's a great exercise to do, annually or every few years to just make sure it's who you want it to be. Okay, next, the disinherited adult child. So from a blended family perspective, I tell you this because, sometimes in the case that I'm talking about specifically, where I have experience in, there might be families that come together and they now have this family made up of different family members, where there's spouses and kids from prior marriages. In that scenario, potentially there could be a child that has no relationship with the parents at all anymore. And so in this case specifically, I had a client where sister passed away and we were going through probate and we were almost to the end, sister's almost done. And it was a very long probate proceeding. And then I got an email from a son that we did not know anything about. We didn't know if he was alive, right? We tried to contact him. We couldn't find any information. He hadn't talked to the sister, the mom, in over 40 years. And he was essentially disinherited from the family, right? Because he had no communication for over 40 years. However, he was still a child, and there was no legal documentation in her will that said, I specifically do not want to include this child. He was not mentioned. And so this son got a portion of the estate, which sister was very upset about because of the relationship that she knew that her sister had gone through with the son. And, it was just so upsetting to her. Had proper estate planning been done, this could have been prevented, right? To make sure that if you do not want to care for a specific child that is by blood an heir, then it needs to be legally documented. Okay. Next, so the blended family and the unintentional disinheritance. And so I had a client whose mom got remarried, and mom passed away. And as my client found out after, mom, when she had gotten remarried, took the assets that she had and commingled them with her new husband. And at this point, all of the assets, because mom has now passed away, it was owned jointly with right of survivorship, are now in the husband's name. And so this family home that my client had grown up in was now gone, right? It was now with this joint ownership with right of survivorship, it was now owned by the stepdad, and he was not giving anything to her, right? So she was not entitled to anything because everything passed to him, because everything was commingled at the point when they got married. This is something, and I will talk about this in detail, about how proper planning could have made sure of whatever mom's intentions were, right? It probably wasn't her intention that her daughter was disinherited, right? So I call it an unintentional disinheritance, because it wasn't her intention. It was just how things were titled, that this is why it then worked out this way, that daughter didn't receive anything because it then went to the stepdad. Okay, the last one is the Brady Bunch. And so, this is, I think, kind of the epitome when it comes to the blended family of what we have heard before about it. But just to kind of give you an idea. So let's say in the Brady Bunch scenario, there you have Mike, who has 3 boys, and Carol, who has 3 daughters. They get married, they form this Brady Bunch. So what happens if Mike passes away? Well, there's a couple things to consider, because I do not remember any episodes where they talked about estate planning. And so I don't know exactly what kind of plan they had in this TV scenario. But we can speculate, right? It's always fun to kind of try and figure that out. Again, I'm a legal nerd over here. So with what we call an I love you trust. And so that's basically just a revocable living trust where they are jointly on the trust. And then when one spouse passes away, all of the assets go to that trust. It's I love you, and I know that you're going to take care of my kids because you love me, right? So it's putting all of the control on that surviving spouse, and them having the ability to really do whatever they want with the assets. So in that scenario I kind of just gave with the client and the stepdad, that was basically the I love you scenario, right? I love you and I trust you to take care of my kids. Another is maybe they didn't have a trust, right? Maybe there was just a will. Well, in the will, maybe Mike lists Carol as the beneficiary. So then at that point, if the estate has to go through probate, because I believe they own that house, the estate has to go through probate, depending on how title was held. She gets all of the assets that are now in her name. Well, what if Carol gets remarried? What happens to the assets at that point? What if she commingles them with her new spouse? Right? If she takes those assets that she received after Mike passes away and she commingles them, now it's community property with her new spouse. Well, then Mike's boys, they get nothing, right? Unless she specifically is caring for them. But she doesn't have to. She has no legal obligation. There's nothing that was set up that makes sure that Mike's boys are taken care of. So these are all things that I'm just trying to kind of get in your trying to give you some ideas on different things that could go wrong and how we can plan for them. So what happens, and just so you know, if you have any questions, please put them in the chat, put them in the questions and answers. I will try and get to them depending on how we're doing with time. And if not, but I will save some time at the end to go through questions. So what happens when someone doesn't have a legal plan in place? So we look at two things, right? We look at incapacity and then when somebody passes away. So when it's incapacity, meaning somebody doesn't have the ability to understand what's going on. So we see this in people when maybe they have a stroke or there's dementia, something that they don't have the ability to understand the legal documents they're signing or what that medical procedure is going to do. It would put them in this incapacity state. And then if there is no estate planning documents done that say what they would want, who they would want caring for them, that's where a court conservatorship would be necessary. And that's where you have a judge deciding who is going to be the one that's going to be in charge, right? Making medical decisions, making financial decisions. It may not be who you would want, okay? Because you aren't actually doing it. And when you have the ability to make those decisions, that's when it goes to a court to make that decision for you. The other is when someone passes away, and this is where probate court gets involved. So in California, a probate is required when you have an estate that has a value of over $166,250, right? If the money or the property is over that amount, it has to go through probate to be able to be distributed to the heirs or beneficiaries. And so what is probate? It's basically just this court proceeding where when somebody passes away, all of the assets that they own have to be to go through this process where creditors can, put up a claim to be able to receive money. And then anything that's left over at the end of the probate process gets distributed either according to their will, or if they don't have a will, it's done through intestate succession, which can be a really big issue for blended families. Because intestate succession basically means who are your heirs? How is the lineup that people would receive as part of your bloodline? And so for blended families, if you have a situation where, let's say there was, a parent and a step parent, and that step parent has raised a child from the time they were, 1 year old and they're now 30, right? But because that step parent never adopted the child, it was never legally theirs, that child that they raised as their own wouldn't be entitled to any of the assets in that step parent's estate through this intestate succession. So it's basically California's estate plan for you. And so that's, one of the big issues. And depending on that blended family situation is how would you want your assets distributed? And you need to make sure you have proper documentation specifically stating that. So probate court is a very long process. It can take 1 to 2 years to complete. It's public, meaning anybody can pull the records and find out what's going on. It's also very expensive. And this is really kind of eye-opening for people if they don't understand what probate is, how expensive it is to actually have to go through that process, and why maybe it's less expensive to just do the estate planning now. While it still costs money, it's not nearly as expensive as probate's going to be. So to give you an idea of how expensive probate is, let's say you have a gross estate, meaning a home with a fair market value of $490,000. And it's not the equity, it's how much it would sell for that fair market value. And then let's say $10,000 in various bank accounts. So a total probate estate of $500,000. So the statutory fees, so this is set by the state of California, say that the fees are going to be $26,000. And then you have additional costs. So filing fees, bond fees, publication fees, probate referee fees, adding up to almost $28,000 for just a $500,000 estate. And so you can imagine the higher the estate cost goes up, the more that those fees are going to be. Okay. So some of the other estate planning tools that we have available to us that some people utilize, just so that you have an idea, is you have joint tenants with right of survivorship, right? So one person passes away with right of survivorship, it just means it goes to the other person that's listed there. Transfer on death. I see this sometimes in bank accounts. I also have seen it in deeds where they have a transfer on death deed. I do not recommend these. I don't know any other estate planning attorneys that do, but I do know that people use them. And when I see them, it's because they weren't done properly, and in which case that leads to problems that we have to fix, which causes a higher cost than just doing an estate plan in the first place. The other is beneficiary designations. So like updating life insurance, retirement accounts, anything where there's a beneficiary that is designated for an account or some type of asset, it would be making sure that that's updated. So those are other ways to transfer assets upon somebody's passing. The bottom line, and really kind of where I'm going with all of this, is that a trust provides comprehensive management for your assets during your incapacity as well as at your passing. And a lot of times people don't think of it from an incapacity perspective, but it's on both sides. Okay, so estate planning documents, when we look at them, we have power of attorney, advanced Health Care Directive, HIPAA authorization, a will, a revocable living trust. And if you have minor children, we look at guardian nominations for those minor children for either long-term and short-term. So I'm not going to go through all of the documents, but I do want to kind of just give you an idea so that you have an idea of what these documents are. The other thing I wanted to mention, just in this kind of blended family situation, is if you were married previously and you and your former spouse had any type of estate planning that was done previously, you need to make sure that whatever was done was complete and like revoked, right? That's what we call it in the legal terms, is we revoke a trust, or, you know, revoke a prior power of attorney. And so you want to make sure all of the stuff, because what we've seen in the past is if it doesn't get revoked, like in an example I gave in the beginning, they just assume everything kind of just cuts off, and some things do by operation of law, but you never want to leave it to your beneficiaries or your heirs to go and figure that out, because if they don't, you could have changed it. You didn't. Okay. So it's, you know, making sure, especially if you had a trust, right? Are there any assets that are still funded in that trust? Right? They have the wrong name on the asset. So it's really making sure that anything that was done before is now revoked, right? And that there's no assets that are named in it. Okay, so when we plan for incapacity, the two documents that are used are the power of attorney and the advanced Health Care Directive. And these are, both of these documents are so important when it comes to making sure that you have this voice, right? If you don't have the ability to say what you want, these are people that you've identified to be agents. And so for the power of attorney, it's identifying an agent to make financial decisions for you if you are unable to do so. And the advanced Healthcare Directive is identifying an agent to make medical decisions if you are unable to. So the power of attorney, a lot of times people get this wrong. It's only it only works while somebody's incapacitated. And so I'll have somebody that calls me and say, oh, I have a power of attorney document and somebody's just passed away. And I say, I'm sorry, that document is for when they are incapacitated. It's not for after passing. The advanced healthcare directive is also important because it allows you the ability to identify certain end of life decisions. So do you want burial? Do you want cremation? Do you want organ donation for transplant purposes? Do you want prolonged life support with extreme measures or not to be on that? Okay, so both of these are important incapacity documents to have. The next is the will. This is the most common estate planning document I think that most people know. And like I said before, the will is this document that you identify who you want to receive your assets, for nominating guardians for your minor kids. When somebody passes away, a will is filed with the probate court, therefore becoming a public record. Having a will alone does not avoid probate court, right? That is like the biggest myth that I hear from people is, oh, I have a will, I don't have to worry about it, my family's covered. But a will alone isn't going to protect them, right? It's not going to prevent having to go through probate court. What does is a revocable living trust. We call the trust a probate avoidance tool. And it's basically just this agreement between the grantor, which is the creator of the trust, and the trustee, the person who agrees to hold legal title to all of the assets in the trust. And they do this for the benefit of the beneficiaries. And so while you are alive and you have this revocable living trust, you are all three of these roles. You created it, you're in charge of the money, and it's also there for your benefit. Generally, when you have a trust, there's no court involvement, which is going to keep costs down. And then the myth I hear with trusts is that they're just for wealthy people, right? But in some of the scenarios I gave in the beginning for avoiding probate, had they had a trust and a house in trust or the assets in trust, it could have avoided having to go through probate. So this is a kind of quick diagram just to show you kind of what a trust does. So in the center, we have the trust, right? You and your spouse are at the top, depending on what kind of trust setup you have. And then all of the assets that you have are pointing to the trust. So they're either going to be named in the trust, they're going to have beneficiaries to the trust. And then upon your passing, the trust assets are distributed to the surviving spouse or your beneficiaries. And so when I say distributed, it really depends on what your goals are, right? How do you want those assets being transferred to the people that you leave behind? The other thing, again, is having a trust is, no probate if the trust is properly funded. So if all of these assets are in the trust properly, then that avoids that whole probate process that I talked about. Okay, so some of the benefits of a trust is, especially from a blended family perspective, is there are several different types of trusts where you can have specifically how you want your wishes honored. So some ideas is you can have a joint trust with your spouse and have very specific language in there that says how you want those assets distributed if something happens to one of you, if something happens to both of you. There's also separate property trusts. So sometimes I see clients that'll come in and they're in a remarriage and they have kids from another marriage and they have all of this separate property, right? Maybe some houses and accounts, investments and things. They want to keep it separate. So we would just create a separate property trust for them. So if something happened to them, they don't have to commingle all of those assets, but they can identify how they want stuff distributed in that separate property trust. I do see it where I'll have clients come in and they'll have one joint trust, and then each client will have their own separate property trust. Similar to that, we also have a joint trust to hold the community assets that will pour into two individual trusts that will hold the separate property of each individual spouse. And so there's lots of different ways to do it. It's really just these conversations that you're having with your estate planning attorney on what your goals are so that we can develop this plan that's going to really make sure that those goals, that we're able to write them down legally. The other benefits of having a trust is it can protect your children's inheritance from creditors, and divorce, right? Remarriage, like I said in the Carol Brady scenario, had a trust been set up, she wouldn't have been able to commingle those funds and Mike's kids would get nothing. You can list your trust as a beneficiary in your life insurance so the funds don't go to any one person unless that's what your goal is. So again, it's making sure you're working through all of these different things. The other is right to occupy language for a surviving spouse. And I'll talk more about that in just one second. So some of the issues that I want you to be aware of so it's issues as well as considerations, right? As you're planning for blended families. I see a question that just came in. I'm almost done, so I'll get to that at the end. Is you have all of these abilities to put specific things in there, right? To think about things and have these kind of scenarios play through and how you want them handled. So one example is what we call right to occupy the home language. And so this is where we will put this language in the trust. And the idea of it is that if there's this blended family and let's say new marriage and the spouse is living in the home and the one spouse passes away and that one spouse wants, because it's the family home, they want the house to go to the kids, to whoever's passed away, to those kids. Well, but they also want to make sure that their new spouse is at least taken care of for the rest of their life. And so they'll say, well, you have the right to live in this house, but here's all the things that need to make sure are getting done. Like who's paying if there's problems with the house, who's paying the mortgage, who's paying insurance. What if you need to sell the house to go buy a smaller house, right? So it's all of these limitations and very specific things in there so that it's very clear. If you are concerned about a child and a step parent getting along, which I see a lot, right? After their parent passes away, you can consider leaving a specific asset to that child. And so like I've seen it where in this exact situation where the parent will leave like an IRA or a life insurance policy, and they'll have just the child as the beneficiary, so that that asset just goes directly to that child. And so there is nothing that needs to be cared for from an estate planning perspective for that child to receive, because they've already received this other asset, right? And so you have the ability to do that if you think there could be conflict when it comes to those relationships. Personal property in the home and being distributed according to your plans. Who has access to it? So this is just such a sad situation. I hear so many times where there's, a new marriage or a step parent, and the kids want to go and get pictures, family heirlooms, something, and then the new parent will not let them in the house, right? And so having all of that personal property specifically identified who you want it to go, so it's very clear. Okay. Continuing, again, there's a lot of issues, so it's all things to consider, is distributions to children. I see this a lot where the parents will come together and they each have their own children from prior marriages, and they'll say, well, we just want half to go to this parent's kids and half to go to this parent's kids. Well, what if there's not an equal number of kids? So in that situation, or, we have, 4 kids together and they each just get 25%. Well, what if one parent only has 1 kid and the other parent has 3 kids? Is that fair to the one kid to the parent who had the 1 kid? Is that fair to that kid? Maybe it is, right? It all depends on the family situation. It's also thinking through is, how are the kids going to be affected? How is the surviving spouse going to be affected with these these decisions that we're making, and how they're going to be? I'm going to jump right to the bottom where I say communication is key to reducing the family issues. That's where we see it, where kids aren't brought in, that things are kept a secret. So surprises can cause emotional and expensive, unnecessary situations. It's a tongue teaser. And that's really what it is if the kids aren't told what's going on, and then they're in this emotional situation where they've lost a parent, and then they get this information, they could be going to another attorney and bringing legal action, right? And so it's trying to prevent that from happening. Okay, the last one is when one spouse passes away and the surviving spouse remarries, where does the money go, right? So this is the Carol Brady situation, is if there aren't proper specific things in place that's legally documented, then that surviving spouse has the flexibility and control to do what they want with the assets. Okay, so if they get remarried, it could go to that new spouse. Okay, so anyone over the age of 18 needs some type of estate planning, but especially if there is a blended family situation, right? Making sure that everything is legally documented. So I have a challenge for you. Go check and see how your property is held. What does your title say? Make sure that it is exactly how you want it to say in whatever family situation you have. If you need help getting an estate plan in place, you can start with a free telephone consultation with a member of our team here. I'm going to put that in the chat. We'll email out the link after. But these are all really important things to think about it, and just to make sure that the families can legally document their wishes. Okay, at this point, we are just finishing up. So I want to thank you so much for joining me. I am going to take questions. Don't worry, I saw a couple come in. But if you need to go, I do know we just have 30 minutes and I want to be mindful of your time. So thank you so much for joining me today. If you don't already, please go follow me on Instagram. I'm at Estate Planning Mom. And at this point, I will take questions from you. So thank you. Okay. I have adult children who are married. Can I protect my property from the wife? So you can put protections in place for the trust that you're setting up. And we would just have specific language in there that limits how the assets can be distributed to, to your child, or to your children, and how it can't be distributed to the wife, and maybe having what we call a lifetime asset protection trust, where the money is to stay in trust. They're not just going to receive it, because that's the biggest thing where there's no protections, is that if somebody, like, let's say assets go to that person through probate, right, to your child, if there's no protections in place, they take that money that they get from probate and they put it in their joint checking account with that wife, right? And then at that point, it becomes community property. Okay. And then there's no way of protecting it. But if it's protected in trust, right, as long as it's not a trust where they're getting distributions at 25, 30, 35, which works for some families, it depends on the situation. Anytime they get that money, so that distribution at 25, the distribution at 30, the distribution at 35, they take that money and they commingle it with that spouse in their joint checking account, it is no longer protected. But we do have specific trusts and language that we can put those protections to keep it in a lifetime asset protection trust, to make sure that that money isn't being distributed just on a timetable where they can take that money and commingle it. Okay. And that question comes up a lot, with parents wanting to put plans in place. You're welcome. What happens when minor children are listed as beneficiaries on life insurance or investment accounts? Okay, this is probably my most favorite thing to talk about, as we do focus on planning for families with minor kids. And again, if you don't follow me on Instagram, I have a ton of videos on this exact subject. So I will share it with you. So if you have minor children, so in California, it's anybody under the age of 18. If you have a minor child listed as a beneficiary on a life insurance policy or an investment account, and that child was to come into money, so if something happened and they were to receive that benefit, because they are a minor, they can't actually inherit the money, right? What would happen is the guardian or somebody would have to petition the court for guardianship of the estate of that child, where then they would have guardianship over the assets. And then that guardian can contact the insurance company, which I've worked with clients on this, where they won't just release the money. It has to go through this court proceeding. And then it's going to go into this court blocked account, where it's likely the guardians won't have access to the money. The kids won't have access to the money. And then they get all of it when they turn 18 years old. And that is, from some of the benefits that I see, a lot of money for an 18-year-old that's probably not financially mature enough to be able to be responsible at spending that money. And so what I talk to clients about is, rather than having the minor child listed as the beneficiary, and this works even if you're married, right? You can, if you're married and you have your spouse as the primary beneficiary and the kids as the backup beneficiary, and if something happens to both spouses or both parents, that money's going to go to the kids, which is what you want, right? You want that money to be there to take care of the kids, but that's not always what happens. And so what we generally will do with clients is we will create a trust, right? Revocable living trust. And we will say, however you want the money distributed for your kids, if they're minors, like I said, 25, 30, 35, they get distributions, but that money is protected in trust for them. And so then what you're going to do is, once you have that trust, you can say on your life insurance policy, well, I want the spouse to be the primary beneficiary, but then I want the trust to be the backup beneficiary. So you're not listing the kids as a beneficiary, you're listing the trust, so that if something happens, that money goes directly into the trust for the benefit of the kids, to be distributed at 25, 30, 35. Okay, does that make sense? Okay, great. So I will hang out for just another moment. I don't think I saw any other questions come in. Again, if you need help getting your estate plan completed, please make sure to click the link and get a free phone consultation scheduled. In that consultation, a member of our team is going to go through what our process is, why planning is important, and to go over pricing packages so that you know how much estate planning actually costs. Okay, so you'll get that in the email, but it's also there. And just so you know, if you are in the Ventura area, we are actually having a live in-person workshop next Saturday. That's May 21st. So you should be able to go to our website, click the link to get registered. So if you know of anybody in Ventura County or LA County that want to come to Ventura for a live workshop, It's our first one that we've had in quite a few years, so I'm looking forward to it. But it's going to be an hour long, and we go through a lot of stuff, right? So it's really about getting their planning started. Okay, thank you very much. Okay, I don't see any other questions. Thank you. Thank you for those. Okay, take care. Have a wonderful afternoon.